Hi everyone. So today's final session is on the assignment discussion session. But before I carry on with the assignment discussion, I'm going to go through briefly about the module spec again, which we did at the start of the sessions in Learning Outcome 1, and then I'm going to summarize and go through Learning Outcome 1, 2 and 3 with you again, and then we will do the assignment discussion. In the last session, I showed you a lot of journal articles that are all available on Moodle for you to use as additional reading, globalization articles. Some of them were quite lengthy and some quite short, and they're on globalization, the legal requirements within trading internationally. So a little bit on the module spec before we carry on with the summarising the learning outcomes and then the assignment session. So the international trade unit is a level 7 unit, and it's 20 credits. The aim of the unit is to develop the learners' understanding about international trade law. Learners will focus on such things as competition policy, the principles and practices of international sales contracts, and analyse associated issues to an organisation trading globally. And we've looked at learning outcome 1, 2 and 3, which are all recorded for you to use later. But what I'm going to do now is summarise through each learning outcome so that you've got a better idea before we go and tackle the assignment session. So let me just share the learning outcome with you. So we'll firstly go through learning outcome 1. Okay, so the first learning outcome is learning outcome 1, which was to look at understanding the concept of strategical trade, environmental competition, and preferential trade arrangements in international trade. So the unit aim is to look at developing learners' understanding of international trade law, as I mentioned earlier, and focus on international trade policy, competition policy, and international sales contract. The indicative content for learning outcome 1 is to look at international competition policy prohibiting agreements of practices that restrict free trading. We looked at environmental regulations, strategic environmental protection, the rules and principles of general agreement on tariffs, such as GATT, and the World Trade Organization functions. We looked at understanding the concept of trade, environmental competition, and preferential trade arrangements in international trade. We looked at the strategic trade theory, which was emerged again in 1980s. And which was challenges the traditional neoclassical view of free trade. Strategic trade suggests that a national government can make its country better off if it adopts certain trade policies, even if other countries do not cooperate. For instance, in Brander and Spencer, 1985, it illustrated that subsidies for domestic firms in industries with significant economies of scale can enhance national welfare by shifting profits from foreign to domestic firms. We looked at environmental competition in international trade, which it refers to how countries compete based on environmental trade and standards. It encompasses the debate over whether stringent environmental regulations negatively impact a country's international competitiveness. And we looked at how some academics argue, such as Michael E. Porter, that stringent environmental regulations can stimulate innovation and efficiency, ultimately leading to improved competitiveness. We looked at the preferential trade arrangements, which are agreements between 2 or more countries that provide access to each other's markets. And this can include reducing tariffs, quotas, and other trade barriers more than what is offered to non-member countries. We looked at the European Union as being an example of preferential trade arrangements with a large level of economic integration. Then there was a video on international trade, which was explained, and you could look at that in your own time, please. And it's quite an interesting video because it looks at the issues of globalization and the issue of how you would trade with a different country with importing, exporting. We then went on to 1.1 and looked at the role of international competition policy for environmental regulations and strategic environmental protection for organizations trading globally. And we looked at the role of international competition policy in relation to environmental regulations and strategic protection for organization is engaged in global trade, multifaceted and complex. Analysing this role, it involves how these policies interact and impact global trade, environmental sustainability and organizational strategies. We looked at international competition policy and environmental regulations. International competition policy includes laws and regulations designed to promote competition and prevent monopolistic practices and can significantly intersect with environmental regulations. And on the other hand, stringent environmental regulations in one country can affect the competitiveness of its firms on global stage. We then looked at the Organization for Economic Cooperation and Development, OEC, who has discussed the importance of aligning competition policy with environmental objectives to support sustainable development, which was in the OECD report 2019. We then went on to look at strategic environmental protection for global organization, and which referred to the deliberate actions taken by organizations to not only comply with environmental regulations, but also to gain competitive advantage. This can include adopting eco-friendly practices, investing in sustainable technologies, or developing green products. And we looked at the Porter hypothesis 1991, which suggested that stringent environmental regulations can spur innovation, leading to improved resource efficiency and competitiveness. We looked at the impact on global trade organizations, which was organizations trading globally must navigate varying environmental regulations across different countries. They need to align their strategies with international competition policies while also considering environmental protection as a strategic object. We also concluded in regards to international competition policy and how it is an important aspect and plays a crucial role in shaping how environmental regulations impact global organizations. We then went on to 1.2, which looked at evaluating the contrast theories of market imperfections, distortions to measure trade barriers. And we looked at evaluating and contrasting theories of market imperfections or distortions and how it's so important for understanding the issues around this in regards to trade barriers. We looked at theories of market imperfections and distortions such as mercantilism and neoclassical trade theories. We then went on to measuring trade barriers, and we looked at tariffs and quotas and non-tariff and quotas. So traditional measures of trade barriers include tariffs and quotas. The neoclassical view suggests that these barriers distort market prices, leading to inefficiencies in the global allocation of resources. We looked at non-tariff barriers such as regulatory standards, subsidies and customs, and more subtle and can be more significant than traditional barriers. We then went on to evaluation. Evaluation and contrast, and looked at mercantilism versus neoclassicalism and the role of non-tariff barriers. In conclusion, we looked at how theories were important in market imperfections and distortions and how they provide an essential framework for understanding and measuring trade barriers and the relationship between mercantilism and neoclassicalism and how it's quite important in regarding trade barriers. We then went on to 1.3, which we looked at critically evaluating types and rationales for preferential agreements. We looked at the types of preferential agreements, which are treaties between two or more countries that agree to lower trade barriers more than what is offered to non-member countries. We looked at types of preferential trade agreements, which are free trade agreements, FTAs, involve countries agreeing to eliminate tariffs. quotas and other trade barriers. We also looked at customs unions and common markets and economic unions and the importance of them. We looked at the rationale for preferential trade agreements, so economic integration and market access, which was one of the main motivations of preferential trade agreements. We looked at political and economic stability and how it serves to promote political and economic stability within different regions and the strategic interests as well. We then went on to look at the development and economic diversification for developing countries and foreign investment. We went on to look at response to globalization and multilateralism limitations in regards to World Trade Organization. And then we had a critical evaluation of trade creation versus trade diversion, impact on non-members, complexity and overlapping agreements, and looked at the political and economic power dynamics. In conclusion, we looked at the preferential trade agreements, how they offer several benefits, including enhanced market access and regional integration, and they also come with potential downsides such as trade diversion, complexities, and potential inequalities in global trade. We then went on to 1.4, which was to analyse the economic basis of rules and principles of GATT, which is the General Agreement on Tariffs and Trade. And we looked at when it was established in 1947 and how it was incorporated into World Trade Organization in 1985. We looked at the most favoured nation MFN treatment, which was one of the principles of GATT, which requires that any trade advantage given by a member country to a product originating or destined for any country must be extended to GATT member states. We looked at the national treatment principle, which mandates that imported goods should be treated not less favorably than domesticated produced ones that have entered the market. We then looked at the prohibition of quantitative restrictions and like quotas aiming to eliminate non-trade barriers that can distort international trade, and then special and differentiating treatment, which recognizing the developmental differences between countries as GATT has incorporated. We looked at dispute settlement mechanism to resolve trade disputes among member states, and then we looked at why GATT is so important in regards to reducing trade barriers and stabilizing trade environment and facilitating trade practices. We then went on to 1.5, which was critically analyze the workings of the World Trade Organization and predecessor agreements. We looked at GATT, predecessor to the World Trade Organization, the structure and function of GATT, when it was established in 1947. And it was a multilateral agreement aiming to reduce trade barriers and how GATT was successful in significantly reducing tariffs and setting foundation for global trade rules. We looked at the challenges and limitations GATT faced. We also looked at the evolution and expansion of the World Trade Organization, which was established in 1995. The successes have been effective in providing a stable and predictable environment for international trade, resolving around 500 disputes through its dispute settlement mechanism. We looked at the criticism and challenges of the World Trade Organization as well, and the critical analysis, so decision-making processes by both GATT and World Trade Organization, and the inclusivity versus efficiency. We then went on to look at dispute settlements with GATT and World Trade Organization, and impact on global trade, such as both GATT and World Trade Organization have influenced global trade, contributing to its expansion and integration. And we looked at how, concluded with the effectiveness of GATT and how it played it's quite effective and challenging, and how World Trade Organization came into force. And there's some references that we referred to. So this is how, this is me summarizing, going through learning outcome quite quick. The next one I'm going to go through is learning outcome 2, so you've got a better idea before we go into doing the assignment. So I'll just share learning outcome 2 with you now. So as we've gone through Learning Outcome 1 and looked at the issues around World Trade Organization GAP and in regards to competition policy, now we'll be going on to looking at Learning Outcome 2, and it's it'll be a quick summary of Learning Outcome 2, because then we've got to move on to Learning Outcome 3 and then the assignment discussion. So Learning Outcome 2, to understand the underlying principles, rights and regulations of international sales contracts. So indicative contract, we're going to look at contract for sales of goods and products, international sales of goods contract, directives on certain aspects of consumer goods and international sale of goods, and the Vienna Convention for international sale of goods. So 2.1, which was looking at analysing constituents for the contract for sale of goods or products. So looked at the Sale of Goods Act 1979 and the Consumers Rights Act 2015, and we're going to look at the fundamental elements of a contract for the sale of goods include, firstly, we looked at offer and acceptance, which is the basic structure of any contract. Capacity to the contract, so that both parties have the legal mental capacity. Intention to create a legal relation, so there must be a clear intention from both parties to enter into legally binding agreement. Consideration, the exchange of value. Legality, so the contract must have a legal purpose and not for any sort of illegal purposes or to against public policy. Certainty of terms, so the terms of the contract must be clear. So if there's any sort of breach of contract, everything is clear within the terms, such as payment terms, delivery dates, and any other conditions. The goods, so the subject matter of the goods must be, the Sale of Goods Act defines that. Transfer of property, so the contract should clearly state that regarding the transfer of ownership. Transfer of risk, so if there's any loss or damaged products. Compliance with statutory regulations requirements. So in the UK, contracts for sale of goods must comply with statutory requirements such as Sale of Goods Act and the Consumer Rights Act. And summarised it that why a contract for sale of goods and products is legally binding contract, and these elements must be part of this contract. 2.2, evaluate the rights and obligations imposed under international sales contracts. So here we're looking at international sales contracts, not within the UK. So it's really important to evaluate the rights and obligations imposed under international sales contracts. It involves a more detailed look at the complex legal framework that governs these contracts. The key instrument governing international sales contracts is the United Nations Conventions on Contracts for International Sale of Goods, which is CISG, and which is widely adopted by various countries to provide a uniform legal framework. Rights and obligations of the seller. So this is at the seller. So delivery of the goods. The seller must deliver the goods, hand over any documents relating to them, and transfer the property in the goods as stipulated in the contract. Conformity of the goods. So the goods must conform to the quality. Disclosure. So the seller is obligated to disclose to the buyer any facts relevant to the goods that they know or could not aware if they may affect the value of the goods. So if there's anything wrong with the goods, or if they're damaged or which may affect the value. Rights and obligations of the buyer. So we looked at the seller, now the buyer. Payment. The buyer is obligated to pay the price for the goods. Inspection of the goods. The buyer has the right to inspect the goods within a reasonable time after their arrival and must report any non-conformant to the seller. Acceptance of the goods. Upon receiving the goods, the buyer must indicate acceptance. Remedies for breach of contract. For the seller, if the buyer fails to pay the price or take delivery, the seller has the right to demand payment, deliver the goods, or cancel the contract. For the buyer, if the goods do not conform to the contract, the buyer may demand repair, replacement, reduce the price, or seek damages. Jurisdiction, applicable law. International sales contracts typically specify the governing law and jurisdiction of any disputes. The CISG provides a framework, but parties can opt and choose the law of a specific country to govern their contract. So, each country has its own laws. Risks and insurance. Contracts often stipulate who bears the risk for loss to goods at each stage of the transaction. International commercial terms, Incoterms, are commonly used. Cultural and legal considerations. Parties must be aware of cultural differences and varying business practices, which can affect contract negotiations. Limitation of liability and force majeure. Contracts usually include clauses limiting liability and addressing situations. So international sales contracts impose specific rights and obligations on both buyers and sellers aimed at facilitating smooth and predictable trade transactions. Contracts are governed not only by the agreed terms, but also by the international convention like the CISG, and are influenced by the jurisdiction, considerations, cultural nuances, and practical business practices. So 2.3, analyze the validity of rights and obligations of international sales contracts. Analyzing the validity of rights and obligations in international sales contracts involves examining the enforcement and applicability of these contractual elements. The validity of these rights and obligations is essential for ensuring that the contract is legally binding and enforceable. Compliance with governing law. The validity of rights and obligations in international sales contracts largely depend on their compliance with the governing law. The formation of a contract. The contract must be formed according to the principles that are recognized internationally, such as offer, acceptance, intention, legal relations, and consideration. Clarity and certainty of terms. So the terms of the contract and the rights and obligations must be clear and certain. Legality of purpose. So the contract must be for a legal purpose and not contravene public policy. Capacity and authority of the parties. So as we mentioned earlier, the legal parties must have the legal capacity to enter into that contract. Mutuality of obligations, so the contract must bind both parties with mutual obligations. Conformity with international trade norms, the contract must conform with international trade norms and practices, such as the use of international commercial terms. Incorporation of necessary clauses. Certain clauses are critical for international contracts, such as dispute resolution mechanism, choice of law and force majeure. Compliance with export and import regulations, and then the validity and rights obligations international contracts hinges on several factors, including compliance, governing law, and clarity. 2.4, analyze the implications of making international contract online. Now, this is really important when it comes to making contracts online and taking into account the different elements that will impact on this and any sort of implications. So jurisdiction and implication law, contract formation and electronic signatures, and this is really important in the validity of contracts, and signatures are recognized due to the jurisdiction and the law that relates to signatures, the Electronic Communications Act 2000 in the UK, electronic signatures in Global and National Commerce e-Sign Act in the US. Authentication and security. Ensuring the authentication of parties include an online contract is crucial. The risk of fraud and misrepresentation is higher in online environments. Data protection and privacy laws. Language and cultural difference play a big part in globalization. Technology and infrastructure, reliability, consumer protection laws, keeping a record and accessibility in cross-border taxation. In summary, while making international contracts online offers convenience and efficiency, it's also introduced complexity relating to jurisdiction, legal recognition of electronic agreements, security, data protection, compliance with various laws. And these are the references we've used for Learning Outcome 2, and some of the resources are on there, and the links that you could go on to for further reading on Moodle are just there as well. So that's going through Learning Outcome 2 quickly. We'll now go through Learning Outcome 3 and then go on to the assignment session. So this is Learning Outcome 3. And here we'll be looking at being able to analyze issues associated with an organization trading globally. So the indicative content is the political economy of trade and instruments of trade policy, the open economy, exchange rates and international capital flows, exchange rate management and its impact on economic fundamentals, currency in open macroeconomy, finance mechanism for trade, and involving letters of credits, bills of exchange. So the key terminology being able to analyze issues associated to organisation trading globally. We looked at legal issues such as compliance with international and local laws. So organisations must adhere to the laws and regulations of each country. We also looked at contractual challenges, so differences in legal systems and contract laws. We looked at economic issues such as currency fluctuation, market dynamics, and cultural issues such as cultural sensitivity and communication. So understanding cultural differences is vital. Consumer behaviour, so global organisation must recognise to adapt to consumer behaviour. We looked at political issues, political stability and policy changes. We looked at international relations and logistical issues such as the supply chain management and distribution strategies. We then went on to look at technological issues such as adaptation to local technologies and why that is so important when trading globally. We also looked at elements of trade, cybersecurity, and how that is so important when trading globally in regards to any issues of cybersecurity, any sort of issues around, any sort of fraud or anything. Anti-discrimination laws. We also looked at environmental and ethical issues such as sustainability practices and local and global regulations. We then also went on to look at human rights management and how that is so important within global trading, such as diversity and inclusion, and expatriate management, so if the staffing want to relocate, and how we have to provide cultural adjustment for them so they can relocate, and also the need for careful handling. We also looked at how important it is to look at array of issues spanning legal, economic, cultural, political and logistic challenges before going into a business model in addressing a global exporting and importing. There was a video there that you could look at in your own time on what global trade deals with about, and it's TED with talk of Hayley Edwards, and it's quite an interesting video to have a look at. We then went on to 3.1, which we identified types of exchange rates, regulatory and legal associated to an organisation trading at international level. We went on to look at the types of exchange rates, such as floating exchange rates, fixed exchange rates and managed floating rates. And then we looked at the real versus nominal exchange rates as well. We then went on to look at the regulatory issues such as trade regulations and tariffs. So how you must understand and comply with the import and export regulations, tariffs and quotas of different countries is really important before you start trading between them. We looked at customs and border protection, regulations, including declarations. We also looked at international sanctions and embargoes, and how they comply and how they are different in different countries. We looked at foreign investment laws, restrictions and specific legal requirements for foreign entities. We looked at legal issues such as contract law, so the different principles within different countries. And it's really important that you are drafting and enforcing international contracts within the country that you are trading with. International property rights, so protecting patents, trademarks, copyrights. Employment law, we looked at the importance of employment law, so how they must comply with labour rights, wages and working conditions, because it's really important that you take into account the employment laws. Data protection and privacy, so laws such as GDPR in the European Union and anti-bribery and corruption laws. We then went on to other considerations, which is environmental regulations, and why it was so important for industries to comply with these regulations. and health and safety standards, and why it's so important that they meet the health and safety requirements in each country, as each country will have its own legal frameworks, and it's really important that you actually understand the effectiveness of each country's jurisdiction. We then went on to 3.2, which was to critically analyse legal rules related to the financing of international sales. So critically analysing the legal rules related to the financing of international sales involves examining the various legal frameworks and instruments that govern how international trade transactions are financed. And we also looked at the differences in legal systems, currency fluctuations, political instability, and the distance between parties. So we looked at letters of credits and UCP 600, which is the Uniform Customs and Practice for Documentary Credits, which published in by the International Chamber of Commerce, ICC, and is the most common set of rules used by the governing letter of credit. We looked at the legal nature of letter of credits, which are separate from sales contracts itself, created an independent obligation of issuing bank to pay against documents that appear on the face to the compliant critic as well. We looked at the critique around letters of credits. We then went on to look at bills of exchange and promissory notes, so negotiable instruments, and promissory notes and negotiable instruments are commonly used in international trade financing, and they are governed by the Geneva Conventions. We looked at the legal enforcement, so they're legally enforced in regards to security impairment. We then went on to look at the trade finance regulations, which was the anti-money laundering, AML, and know your customer KYC financial institutions and KYC regulations. We then went on to base 3 regulations on bank capital and liquidity standards and how banks finance trade, international trade, and the importance of this. We went on to looking at what factoring and forwarding is, and it involves the selling of receivables or future payment obligations to a financer, and the legal framework for these transactions by country impacting their enforceability. We looked at the risk transfer of this as well. We then went on to look at export credit agencies, ECAs, and how the ECAs are government institutions that provide financing, insurance, and guarantees to support domestic companies' export activities. We then went on to look at international legal considerations, so conflict of laws. In international trade, issues of conflict of laws are prevalent. Parties must navigate different legal systems and determine which laws are applicable to their transactions. So if they're doing a sales of goods transaction or global transactions. We then went to look at the UNICITRAL model on international credit transfers, and the aim of this model was to harmonise legal aspects of electronic fund transfers, but has limited adoption, reflecting the challenges of creating a universally accepted legal framework for international trade finance. And in conclusion, we looked at the importance of the legal rules related to financing of sales and diverse and complex involving various instruments. We also looked at the effectiveness of these financial instruments largely depends on the robustness of the legal systems involved and the creditworthiness of the parties. These are the references that we've used for Learning Outcome 3, and these are some of the additional reading that you can go on Moodle in regards to the additional reading for global trade and challenges and opportunities in 2003, which I did show you the article on that, and then the 5 common challenges of international business that you can consider, and the link is there that you need to go on to, but all these are on Moodle for additional reading. There's also an article on global trade on 2023, which I did show you in regards to the changes, more recent changes in global trade in America, China, US, and how these impacted on the global trade and international trade. So have a read of these articles that are on Moodle. I've shown you some of the articles that are on Moodle in regards to that. And there were 5 articles throughout Learning Outcome 1, Learning Outcome 2, and Learning Outcome 3 for additional reading. So we've done a quick summary of learning outcome 1, 2, and 3, and now I'm going to go on to the assignment discussion with you. Thank you. So we've completed a summary. I've done learning outcome 1, 2, and 3 individually, and they're all recorded for you to help you with the assignment. But then within this session, I've also do a brief outline of learning outcome 1, 2, and 3, and now we're looking at the assignment session. So the assignment session, again, international trade law. The unit number is F6187916. And the international trade law, unit level 7. Make sure that when you're doing your assignment, you have this as a heading with your own name on. The unit aim is to develop your understanding about international trade and focus on areas such as international trade policy and analyze the principles of trading globally. So these are the learning outcomes. So the first one, understand the concept of strategic trade, environmental competition, and preferential trade arrangements in international trade. Understand the underlying principles, rights, and regulations of international sales contracts, and be able to analyze issues associated to an organization trading globally. So task 1 of 3. So make sure when you are doing each task, you identify which task you're doing with a heading, have a contents page at the start, have your name, your unit name, your unit number, your own number, and also a contents page, and make sure you identify and put a heading in for each task. So the first one is task 1 of 3. So there are 3 tasks. The unit learning outcome 1. So this is all to do with unit learning outcome 1. Understand the concept of strategic trade, environmental competition, and preferential trade arrangements in international trade. Task assessment criteria to cover 1.1, 1.2, 1.3, 1.4, 1.5. This is what I just went through earlier. So the first part of it is produce a report which considers how the General Agreement on Tariffs and Trade, which is GATT, promotes trade and economic development by reducing tariffs and other restrictions. You must ensure the report firstly identifies, number 1, analyze the role of international competition policy for environmental regulations and strategic environmental protection for organizations trading globally. Number 2, you must evaluate and contrast theories of market imperfections, distortions to measure trade barriers. So I think mercantilism, neoclassicalism. You must then look at critically evaluate types of rationales for preferential agreements. And you must analyze, number 4, the economic basis of rules and principles of GATT. Number 5, you must critically analyze the workings of the World Trade Organization and predecessor agreements. Learners must show knowledge and understanding of the subject area. You must provide references to the relevant case law or legislation wherever appropriate. And you must be able to provide support answers and show evidence of wider reading appropriately. So when you are looking, this is task 1 of 3 tasks. You must identify this as task 1, put in 1.1, 1.2, 1.3, 1.4, 1.5, and put your heading for each one. So as you are doing number 1, put it as a heading. As you are doing number 2, 3, 4, 5, each one has a heading. You must identify this and also use your referencing system, which is Harvard referencing system, and also reference to any case law, any sort of reading that you're doing, them articles that I've shown you, make sure you reference them as well. But you need to be using Harvard system of referencing. The submission is in the form of a report in written format in Word document. The recommended word limit is 1,200 words, excluding diagrams, references, and appendices. Learners are expected to adhere to the word count. A 10% leeway side either way range is permitted before the assessor is instructed to stop reading any further. So you need to make sure you are not going over the 1,200 word limit. If you go over, there's a 10% leeway. So make sure it's a Word document, 1,200 words, excluding diagrams, references, and appendices. And there's expected to be a word count. Referencing, you should fully cite and use a range of case law, academic and reliable sources. As I've mentioned, a comprehensive Harvard system of references is needed at the end of the work. So that is task 1. Task 2, and this is unit for learning outcome 2. Understand the underlying principles, practices, rules, and regulations of international sales contracts. Task assessment criteria covered 2.1, 2.2, 2.3, and 2.4. Assignment brief and guidance. Write an essay which reviews the remedies available to a buyer in the case of a non-conforming goods which fall within the United Nations Convention on Contracts for the International Sale of Goods, Vienna, 1980, CISG, and the Sale of Goods Act, 1979. So again, you will need to have highlight your tasks that you are doing. So you must ensure the essay has number 1, and then you will highlight this and do the work on it. Analyses constitute for the contract for sales and goods and products. That will be one heading, and then you will write about that. Then evaluate, number 2, evaluates the rights and obligations imposed onto international sales contracts. That will be another heading, and then you will write under that. Then number 3, so this is task 2. So number 3, you will analyze the validity of rights and obligations of international sales contracts. And again, that will be a heading, and you will write under that. Number 4, you analyze the implications of making international contracts online, and that will be a heading, and you will write under that. Make sure you have each of them 4 parts that you need to do for your essay as task 2, and then each one as a heading, so that we are able to identify that you've completed each one. Here you must show, again, knowledge and understanding of the subject area. You must provide references to the relevant case law or legislation wherever appropriate, and you must be able to support answers and show evidence of wider reading appropriately. The delivery and submission here. The submission is in the form of a report written in the Word format, so it needs to be Word document. The recommended word limit for this part of it is 1,600 words, excluding any diagrams, references, and appendices. Learners are expected to adhere to the word count again, and a further 10% leeway either side of this range is permitted before the assessor is instructed to stop reading any further. So you need to make sure you are sticking to the adhered word count and the 10% leeway. Otherwise, the reader will stop and none of the rest of the work will be marked. Okay, so these are restrictions that need to be put in place. References, you need to fully cite a range of case law, academic and reliable sources, and a comprehensive Harvard system style referencing list must be included in the end of the works. So every time you do it, you need to use a Harvard referencing style system for all your references and your sources that you're using, and they need to be in chronological order as well. So that is task 2. So we've done task 1. Within task 1, there's elements. So you've got, within task 1, you've got 5 parts to do. Within task 2, you've got 4 parts to do. Make sure each part that you do and talk about is with a heading so that the reader is able to identify that and the assessor. This is the final task, task 3 of 3. Unit learning outcome 3. Be able to analyze issues associated to an organization trading globally. The task assessment criteria to be covered is 3.1 and 3.2. Here, the assignment brief and guidance for task 3 is to produce a report which focuses on the risks and benefits associated with the mechanisms used for the finance of international trade, with a particular focus on the documentary letter of credit. You must ensure the report, number 1, identifies types of exchange rate, regulatory and legal associated to an organization trading at an international level. You must, number 2, critically analyze legal rules relating to the financing of international laws. So you must critically analyze. So there's 2 elements here. So for the first one, you identify the types of exchange rates, regulatory and legal, associated to an organization trading at an international level. That must be the heading, and then it's task 3, and then that is the heading. Then task 3 and number 2, critically analysing legal rules relating to the financing of international sales. Again, make sure that you are heading what you are writing about. So there are 2 elements of part 3, task 3, that you need to look at. Learners must ensure that they show knowledge and understanding of the subject area, that you're able to provide references to relevant case law and or legislation wherever possible and appropriate, and be able to support your answers and show evidence of wider reading appropriately. And the wider reading is the additional reading that we've given you so that you could look at in regards to the learning outcome 3. Delivery and submission. So for this part, which is task 3 and the final part, the submission is in the form of a report written in Word format again. The recommended word limit is 1,200 words, excluding diagrams, references, and appendices. And the learners are expected to adhere to the word count, and a 10% leeway either side of this range is permitted before the assessor is instructed to stop reading any further. So again, you need to bear in mind that you are keeping to your time, to your word limits for each of your assessments and your tasks that you are doing. You are adhering to the word limit, because otherwise you will be penalized for that. So your referencing, again, you should use a range of case law, if necessary, academic and reliable sources. And then when you are using sources, make sure you are referencing where you are getting the sources from. And then a comprehensive Harvard referencing list must be included at the end of the work. You need to make sure that you are doing each task individually. So you've got a limit on each task. So task 1, is to do with learning outcome 1, 1.1, 1.2, 1.3, 1.4, 1.5. And then you need to produce a report with 5 elements on that report. Make sure you put it as task 1, and then each one, there's 5 elements. So make sure you are heading each element. So number 1, and then you write about number 1, number 2, then you write about number 2, and then carry on doing that for number 3, 4, and 5. So that is within task 1, okay? And you need to make sure it's 1,200 words and stick to the limit. And also you need to make sure that you are using referencing and your sources, citing your cases, but also using Harvard system for referencing. Again, task 2 is looking at learning outcome 2, 2.1, 2.2, 2.3, and 2.4. Here you are writing an essay, which you need to look at 4 elements. Okay, so you'll put it as task 2, and you'll have each one under heading. So analyze constitutes for the contract for sale of goods, number 1, and then write about that. Number 2, evaluate the rights and obligations and imposed under international sales contracts, and then write about that, and each one for 3 and 4 as well. And make sure you have the heading for each one so that the assessor is able to understand that you have done each element of the essay task 2 separately. Again, 1,600 words, make sure you stick to that and stick to the word format. And then referencing, again, make sure you are using a range of case law, academic resources, and reliable sources. And the articles we've referred to are the ones that are on Moodle that you can read in your additional, if you want to reference them for additional sources. And again, Harvard referencing. Then we go on to task 3, which is be able to analyze issues associated to an organization traded globally. And it is looking at the criteria that is covered under 3.1 and 3.2. And you need to produce a report again, which will ensure 2 elements of the report, which are firstly to identify types of exchange rate, regulatory and legal associated to an organization trading at an international level. Use that as a heading and then write about that. And then the second one is critically analysing legal rules related to the financing of international sales. Again, you have to refer to case law and any legislation and be able to support your answers and show a wider reading appropriate. So for all of them, you need to show that you've got an understanding and you've evidenced something. So if you are talking about something, make sure you've evidenced it. And for task 3, you need to do 1,200 words, okay? And make sure, again, you are fully citing your cases and academic resources and any other sources. And also you are using Harvard referencing system. Okay, so make sure that when it comes to doing your assignment, you are using the appropriate recommendations that I've mentioned to do it in Word format. Make sure you are adhering to your word limit. Make sure you are using your Harvard referencing. Make sure you are looking at fully citing cases, statutes, legislation, any academic sources. Make sure you have headings for each task that you do. So task 1, and then the elements you do within task 1. Task 2 and the elements you do within task 2, task 3 and the elements you do within task 3, and all must have headings, and make sure it's clear for the assessor to be able to look at that you've completed every learning outcome. So task 1 would relate to learning outcome 1, task 2 would relate to learning outcome 2, and task 3 would relate to learning outcome 3. Make sure you have your name on each one. Make sure you have your unit number on each one and the unit name as well, the title of the unit, and make sure you have your own college ID, and make sure you are able to have contents page for each task so that the assessor is able to identify it, and make sure that you are following, as mentioned on these unit aims, the learning outcomes that are on this unit criteria, so that you are able to complete all the tasks. I just want to say that make sure everything is clear so that the assessor is able to submit everything, and also use the additional reading that we have done in learning outcome 1, 2, and 3, the articles to help support your answers, and also them articles are available on Moodle for you to have a look at, and there's ebooks on Moodles for you to have a look at, and additional sources for you to complete the 3 tasks. Now, finished the assignment discussion, I've analysed learning outcome 1, 2, and 3 with a summary of each one, so it's easier for you to understand, and also discussed the assignment session. Thank you for attending today's session, and if you have any questions, please email learnerworks@ukvarsity.co.uk. Thank you for attending today's session.